everyone. Welcome to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0. As we're heading into Trial 2.0, we are 8 days away. And this is episode 133, Full Steam Ahead. Bev says no continuance. So last week there was a motions in limine hearing, which took place over 2 days. On one of those days, Judge Bev ruled that she is not going to continue this trial. So in one of the hearings, Alan Jackson requested a stay, a continuance, so that trial would not begin until after at least April 25th, because as you know, they have the federal habeas corpus petition that they are awaiting on right now. So, because of the timing and everything, they wanted a few more weeks. Well, Judge Bev immediately ruled no, she's not going to stay the trial, but she did kind of come up with a solution which kind of makes sense. They are scheduled. She's already sent out the subpoenas and everything to the potential jurors, so that's an issue. And she said it could take another like 10 weeks, adding on to that timeline if they had to wait for another trial. 10 weeks to get the subpoenas out and get the juror feedback and everything back. So, anywho, they she said she's not going to stay the trial, but she's going to continue the jury impanelment beginning April 1st, which is 8 days from now. And depending on how long it takes, which it could take a couple weeks because this case is so high profile and people in Massachusetts especially have heard of this case. So, it could take a while. So, she says jeopardy doesn't attach until they are actually sworn in, so they can impanel a jury, but they won't swear them in until after April 25th. They'll revisit it. She said she'll revisit it if they're close to April 25th, then, she might just stay the trial for a few days or however long, until April 25th. So we might not have actual testimony and opening statements until after April 25th, potentially. But she's still going forward with impaneling a jury beginning April 1st. So we're going to go over a bunch of new documents that just came out and a bunch of documents that dropped, including the defendant's motion to stay, which just dropped this morning. This is an appeal for basically Bev's decision to not stay the trial. So we'll read that. Up first, let me shrink myself. Please hit that like button. I always forget to say that early in the stream, but please hit that like button. And let's begin. So we have up first, I'm not going to read through this, but this is the decision, the memorandum and order on the petition of writ of habeas corpus. So timeline, it's very confusing and it's all happening really fast. So if I get details wrong, I apologize. But basically, her federal appeal was already denied. Actually, this is the SJC, I believe. This Sailor is with the SJC. But he basically said you can appeal this to the First Circuit Court in his findings. So he denied the petition. He goes on for 28 pages about it. You guys can read it on your own, but he does say you do have some standing and you might be able to do this, federally. You might have more success because it is a constitutional right, a federal constitutional right versus states' rights. So, anywho, he denied it. She then appealed his decision and is going to the First Circuit Court, which I guess is above him. I don't know the whole, structure of it, but so that is kind of where that's at. So they're waiting on that. And then they also did so on this is where it also gets confusing. So on the 20th, which was Thursday, this was an appeal right after Judge Bev said she's not going to stay the trial. So then they appealed it. This was an 11-page filing all about, laying out the whole argument as we've kind of read through before. It's very similar, the double jeopardy clause. This is what happened. These are the notes that came back from the jury. This is the, this is the timeline. All that stuff's in here. So then we have um, a motion to stay. Now this is different, and it's a little bit different than the one that she filed on the 20th. And I'm not sure if it's because there was a ruling on that, or see, this is where it's all getting confusing because things are happening so fast and things are getting denied very quickly. Um, and then I believe it was the motion to stay was denied potentially, and now here she's appealing that again. So we're going to read this one. I'm sorry, and I apologize for not having the actual all the specifics, but it's been going by fast, and it's like here's this, and then something gets filed, and then it gets an answer right away. So apologies, but they are appealing the stay uh, uh, decision to not stay the case. So here is Appellant Karen Reed's motion to stay state court proceedings pending appeal. Now comes the appellant Karen Reed and respectfully moves this honorable court pursuant to a U.S. statute and a federal statute for a stay of her trial scheduled for April 1st, 2025, in Norfolk County Superior Court, pending the resolution of this appeal, contending that such trial will violate her double jeopardy rights. The respondent takes no position on the appropriateness of the proposed remedy in this particular case. On February 18th, 2025, just 1 week after the conclusion of her state court appeal, Reed filed her federal petition for habeas corpus, alleging that her pending April 1st, 2025 retrial in Norfolk County Superior Court on charges of second-degree homicide and leaving the scene of a collision will violate her federal double jeopardy rights. After oral argument on March 13th, 2025, the district court denied Reed's petition. Before denying the petition on the merits, the district court found that one, Reed, who is on pretrial release pending her state court trial date, properly brought her petition under the statute. That two, she satisfied the custody requirement to bring a habeas petition. And three, she exhausted her state court remedies. And four, no abstention doctrine barred it from considering the petition. The district court granted a certificate of appealability, finding that Reed made a substantial showing of the denial of a constitutional right as to all claims. So that is, she needed that certificate of appealability to go forward through to that First Circuit Court. Reed filed a notice of appeal on March 13th, 2025, the same day that the district court denied her petition. Pursuant to the expedited briefing schedule agreed upon by the parties, this appeal will be fully briefed on March 26th. So that is in 2 days, 2025, just 4 business days before Reed's scheduled retrial. On March 19th, Reed filed in the state superior court an assented to motion to continue trial on April 28th to permit her to appeal the denial of her double jeopardy claims. The superior court denied the assented to motion. So Judge Beverly is the superior court. She denied the assented to motion. That was basically meaning the Hank agreed to it as well. Like he wasn't opposing it. So he was agreeing that, yeah, we could stay the trial for, 4 weeks or whatever. So the court denied the assented to motion, ruling that the jury selection would begin on April 1st and that it would appear the defense on the motion again before the jury is sworn if it would hear the defense, it would hear the defense on the motion again before the jury is sworn if Reed's appeal remains pending. So if they're not sworn in yet, like I said, she'll hear the defense again and she'll revisit it. So on March 20th, Reed filed a motion to stay in district court. The district court denied the motion on on March 21st, so it was denied Okay, without explanation. That's a bunch of garbage too. Like they just denied it, no reason. As the Supreme Court has observed, the rights conferred on a criminal accused by the Double Jeopardy Clause would be significantly undermined if appellate review of double jeopardy claims were postponed until after conviction. As the Supreme Court has observed, the rights conferred on a criminal accused by the double jeopardy claim would be okay. Oh, that is I just read that. Um It's the way that the images came out, and the person who, took pictures of this, sorry. It is guaranteed, or it is a guarantee against being twice put to trial for the same offense. So these, obviously, double jeopardy is to protect her from being tried for the same things twice, even though this would obviously be a second time around. Obviously, these aspects of a guarantee's protections would be lost if the accused were forced to run the gauntlet a second time before an appeal could be taken, even if the accused is acquitted or if convicted, as her conviction ultimately reversed on double jeopardy grounds, she has still been forced to endure a trial that the double jeopardy clause was designed to prohibit. So it's not just she can appeal later if she gets convicted. No, it's the stress of going through a trial, it's the finances of going through a trial, and it's not just her either. I mean, it's family members and whatnot too that are affected as well. It's not just Karen, although Karen is the number one greatest affected out of all of them, but her family member, it's stressful on everybody. And it's stressful on the O'Keefes going after someone repeatedly when they don't have the evidence and the evidence doesn't point to her guilt, but yet the state just continues to prosecute her multiple times in order. If you can hear that, it's very windy here in Chicago today, I just want to say. And my windows behind me, you can hear it on very windy days, so apologies. Um, it's kind of distracting to me. But anywho, I don't know what I was saying. Um, what was I saying? I don't know. Let's move on. All right. So under Abney, a defendant facing federal charges is entitled to a stay pending adjudication of her double jeopardy claim unless the claim is found to be frivolous. The petitioner respectfully submits that the defendant facing charges in state court is entitled to the same protection, affirming stay of state court proceedings because petitioner was entitled to have his double jeopardy claim litigated before being retried. So it is that's what I was saying, was that it is stressful, it's finances, it's all sorts of undue burden on the defendant and the family members and loved ones of the defendant, especially if they are innocent. And a retrial when she's already been acquitted, it denies her of being free from having to go through that all over again. Enjoining state prosecution in order to permit the meaningful adjudication of a petitioner's claim under the Double Jeopardy Clause. Federal statute expressly provides that a habeas court may, pending appeal, stay any proceeding against the person detained in any state court or by under the authority of any state for any matter involved in the habeas corpus proceeding. After the granting of such a stay, any such proceeding in any state court or by under the authority of the state shall be void. Alternatively, assuming arguendo, the court finds that it must apply the generally applicable test for issuance of a preliminary injunction reflecting parties' agreement that that standard applied. The petitioner respectfully contends that 1. Reed will be irreparably harmed by the denial of a stay, which would force her to undergo a retrial that she contends violates her double jeopardy rights. Reed has a strong likelihood of success on the merits for reasons set forth in her opening brief with the court, and the district court found the issues raised by her petition to be substantial. 3, the respondents will suffer no irreparable harm. So Judge Canoni is in Norfolk District Attorney's Office, right? Isn't that who's on here? They're not going to suffer any irreparable harm by not going to trial on April 1st. The respondents will suffer no irreparable harm from a stay pending adjudication of Reed's petition. Indeed, the Commonwealth agreed to an approximately 4-week continuance in state court, and for a stay is therefore in public interest. I think that is going to be working for Karen. The fact that the Commonwealth was like, yeah, okay, it's an assented to. We don't oppose it. We'll agree to it, even though it's more for your benefit, but we'll agree to it. Is kind of what that means. But at the same time, I think that's going to go to, arguing Karen's point that they aren't that opposed to at least a 4-week continuance. So the First Circuit Court can look at that and be like, well, yeah, the Commonwealth wasn't opposed to it. So why did Judge Bev, choose not to go forward with a stay? The Superior Court's statement that it would rehear Reed on the motion to continue prior to the jury being sworn is not sufficient to protect Reed's rights. If the Superior Court again denies Reed's motion at that point, she will immediately be placed in jeopardy a second time with no ability to seek a stay with this court to prevent that she asserts what she asserts is a violation of her constitutional rights. Additionally, Reed's trial counsel cannot realistically be expected to select a jury without knowing whether the trial will include 3 counts or only count 2. So, I mean, that is an excellent point. How are they supposed to prep for trial unless they know which count specifically? I mean, they can really tailor their arguments and whatnot if they're doing just count 2. But if they have all 3 counts to contend with and it's not helpful, I mean, it helps them to learn if, the Commonwealth's going to drop those or if the feds are going to drop those charges, because then they can just focus on charge 2. But obviously, the Commonwealth or Judge Bev doesn't want them to know that because that would give them an edge. So I think that she wants to hold them to, yeah, just because she said in her argument, well, that it's all 3. You're going to be arguing all 3. The charges. So, I mean, which really wasn't an argument, but that was her excuse as to, well, the charges. You should just be prepared for all of them, basically. In sum, the petitioner respectfully submits that the double jeopardy protections at stake in this matter are simply too important to force Reed to stand trial for homicide in which she contends would be a violation of her rights before having the opportunity to appeal her substantial constitutional claims. So there were some decent arguments in there. Will it go anywhere? We shall see. Um, we shall see, because so far the feds have not been coming to Karen's rescue, so I don't have a whole lot of hope that they will in this case, but we'll see. All right, so now let's move on to motions within Commonwealth versus Karen Reed. Those were the appellant documents, but these are within Reed's case here against the Commonwealth. So this is a Commonwealth's motion to compel communication. This is like wild to me. Commonwealth's motion to compel communications between the defendant and Attorney Yannetti stored within the defendant's cell phone data. So they are asking for privileged communications because they claim that Karen Reed spoke about it in a documentary, that she had some communications with David Yannetti, and now those communications should just be turned over willy-nilly to the Commonwealth because they want it. So here's what they say. The Commonwealth seeks all texts, emails, and written communications between the defendant, Karen Reed, and David Yannetti, restricted to those communications that occurred between January 29th and February 2nd, 2022. Pursuant to a search warrant, the Commonwealth received the contents of the defendant's cell phone. Because of an observed attorney client communication, the phone data was provided with the assent of the defense to the Attorney General's office, and the court ordered taint team protocol was implemented. The Commonwealth received the defendant's phone data with any privileged communications excised, so redacted or removed. Given the defendant's public waiver of the attorney client privilege as it pertains to the defendant's conversations with Attorney Yannetti on January 29th, 2022, and the following 3 days, the Commonwealth is entitled to the communications between the defendant and Attorney Yannetti for this waived narrow period of time. You guys see a pattern? He just likes to use people's words against them, and that's all he's trying to do here. He doesn't have a case, so he's going in and trying to disrupt like one of the most sacred things, which is attorney-client privilege, which is wild. The privilege holder, Karen Reed, has waived her attorney client privilege with Attorney Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29th through February 2nd, 2022. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. The communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. To ensure that only the communications that were waived are provided, the Commonwealth requests that this honorable court review in camera all text messages and written communications stored in the defendant's phone for the time between January 29th and February 2nd. She is going to jump at the bit. Beverly does not like Karen Reed, and she is going to jump at the bit, I think, to look through Yannetti and Karen Reed's text messages during those first 3 days. I think she's going to grant this because she's a vindictive little bitch, and that's what she's going to do. She wants to see those text messages, and she will help Hank. She will spoon feed them to Hank to help him win his case. Not that I don't think it's winnable, but with all the dirty tricks that they're playing, it could be. So it's very, very, very scary. All right. So, in support of this motion, the Commonwealth acknowledges and respects that the attorney client privilege protects privileged communications between a client and his or her attorney. Waiver of privilege. A. Who can waive? A privilege holder or the holder's legally appointed guardian, administrator, executor, or heirs can waive the privilege. B. Conduct constituting waiver, except as provided in Section 524, privileged matter disclosed erroneously or without opportunity to claim privilege. A privilege is waived if the person upon whom this article confers a privilege against disclosure. 1. Voluntarily discloses or consents to disclosure of any significant part of any privileged matter, or 2. Introduces privileged communications as an element of a claim or defense. C. Conduct not constituting waiver. A person upon whom this article confers a privilege against disclosure does not waive the privilege if 1. The person merely testifies as to events which were a topic of a privileged communication, or 2. There is an intentional disclosure of a privileged communication and reasonable precautions were taken to prevent the disclosure. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversations she had with Attorney Yannetti regarding the collision between her vehicle and John O'Keefe. For example, in the defendant's recorded interview with Gretchen Voss on June 20th, 2023, the defendant concedes, question, you never said, did I hit him? I hit him. Answer, I said, did I hit him? And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's capability. I was supposed to say culpability there. And I thought, all right, maybe I said to my mother, just to go forward a second, they were asking me What was it like? Did they come out? What was the house like? Attorney Yannetti uh, and Attorney Jackson and Attorney Little were in attendance along with the defendant and Miss Voss. Second, so then there's no attorney-client privilege. She said that in an interview with Voss, and the attorneys were there. So this is so dumb. Okay. Second, in a Vanity Fair article entitled Karen Reed Tells Her Story, Part 1, a homicide trial in Massachusetts, with a caption, As Karen Reed's second homicide trial looms, she's ready to talk about what she says really happened. Published October 29th, 2024, the defendant, who, according to the publication, was notably aware that anything that she said could be used against her, volunteered a rumor that alleged representations made by the Massachusetts State Police that there is text message between her and counsel that implicates herself is a provable lie. So what? I don't get his point there. Third, in the now airing five-part docuseries on Investigation Discovery and HBO Max entitled A Body in the Snow, the trial of Karen Reed, the defendant professes, and then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out, and or we went to care for himself and he threw up or passed out, and David said, yeah, then you would have an element of culpability. And that's how I thought about things for about 3 days. Because she was given and hand-fed lies from Jen McCabe saying, what did you hit him? I bet they planted that in her mind. The privilege holder, plus she's being charged for it. They took her car. Like she's thinking, did I do it? Like what, I'm sure she's wondering like what exactly happened. She's questioning the situation. That's not any kind of culpability. The privilege holder is the defendant, and the defendant intentionally waived her privilege by disclosing her conversations to a nationwide audience with her attorney. The attorney client privilege can be waived only by the client. In addition to rendering the communications non-privileged, the communications are relevant as admissions and statements of the defendant. These statements are admissible substantively, and Attorney Yannetti's statements to the defendant are admissible pertaining to the defendant's state of mind. I don't know how that's admissible. Also, the defendant's admissions and Attorney Yannetti's statements are relevant to challenge the defense's later purported claims of third-party culpability. Okay, so she thought she did it because she didn't have more information. Once she had more information, then she realized, oh, wait a minute, I didn't do this at all. And it's people that were inside that house. Once the picture starts becoming clearer, that doesn't make anything that she said, contradictory to the third party claims. It really doesn't. It's a moment in time you have one amount or this amount of information, and then another moment in time you have this amount of information. You can't take that back. Like if you all the stuff that you know now in the Karen Reed case, you can't go back to day one and be like, I know nothing. You know all of this stuff now. So you can't take it back. Like that those things start to come out and it changes your opinions and the way that the evidence starts to look. The communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. Moreover, the defense has suggested that as part of its defense, it is likely to pursue a Bowden type defense. The potential evidence is relevant to rebut claims of law enforcement contrivance. And that is where this motion it gets cut off. I don't know if it cuts off or if there's nothing left, but signatures pretty much, but that's the end of Hank's motion there, but he does have an affidavit. He got he started to listen to all the YouTubers out there who are saying, "You don't have an affidavit." And now he's putting affidavits with his motions. He says, "My name is Hank Brennan. I have been appointed special prosecutor assigned as lead counsel for the case of Commonwealth versus Karen Reed. I have reviewed several public statements made by the defendant relative to this case, including but not limited to the defendant's interview with Gretchen Voss and her appearance on an ongoing documentary. The Commonwealth intends on introducing the number of the defendant's statements, including the statements included in the attached motion. Pursuant to a search warrant, the Commonwealth is in possession of the defendant's cell phone data. The data is subject to a taint team. Hold on. They got her cell phone on January 29th. So how would they have her messages or conversations with David after they took her phone? They're asking up until February 2nd, unless they had updated messages on her phone, and it didn't store, they didn't do a Faraday bag and put it in airplane mode and all that. They didn't store it properly, is what I'm getting at. Because how would they know or have her data after the 29th? Oh, but they did get it in the Aiden Carney searches after that, so never mind. The data is subject to a taint team protocol, and any redacted communications are not available to undersigned counsel for review. In case you're not aware, um, last year, I want to say it was like spring, early spring, late winter, they so Aiden was in prison or jail at the time, and they seized his phones and Karen's phones because they were communicating, and they tried to get a federal grand jury, or not federal, a grand jury, to indict them both on conspiring to intimidate witnesses in the case. But the grand jury, who usually would indict anything, decided not to indict them on that. So there's that. So they do have her communications after that point, I would say. All right, so the data is subject to a tainting protocol, and it's redacted communications. All right, so undersigned counsel requests this court review any redacted communications ex parte and provide the Commonwealth all relevant non-privileged communications as requested in the attached motion. I believe the communications requested are non-privileged because the discussions with Attorney Yannetti during the requested timeframe and subject matter of the defendant striking John O'Keefe has been intentionally disclosed to the public by the privilege holder and are no longer confidential. Now, some attorneys like Andrea Burkhart and others have come forward and said like they have a really good chance of getting this, because she talked about it, it does waive the privilege and blah blah blah. But I don't think you should just be able to waive it just by saying, I talked to my lawyer and we had a conversation about this. Like that doesn't make it, I think that doesn't make it waived, but we shall see. I doubt that there's anything in there that can really be used against her, but because this is a Commonwealth and they have been twisting her words ever since the beginning. So they are going to continue to try to do that. So it will be very unfortunate if they do get these if there are even texts. Like who knows, she might not have had that relationship yet where she was even texting Yannetti those first few days. Maybe. But how do they know that there are text messages during those first few days? Did they look at them already? They're supposed to be protected by a taint team and redacted. So how do they know? It's all very confusing. So was she talking to David Unity? Are there text messages? Do they know this because they were given this unredacted version of it? Like was it leaked to them? I have no idea. I'm merely speculating on what this could all be about. But it's going to be unfortunate if they get it because Hank's going to twist, like I said, everything that she says. And speaking of unfortunate, he is also requesting the records for the most recent um, documentary, which was on Discovery or ID, or I don't know. It was on the Discovery Plus app or Max, the Max app as well. So that's where I watched it, the HBO Max. And it was I want to say 4 or 5 episodes, and it was very, very in depth about the case. However, unfortunately, there were a lot of uh what's the word? Anti Karen Reed folks were on there that have already been out in the media talking and on all sorts of different documentaries and whatnots. So they have been overexposed, in my opinion. We had that Tara Harrigan or whatever her name is, who's like obsessed with John. She was also in it. So that just dropped like last week. So, or the week before, I can't remember. So, time is moving fast, moving up to this trial, let me tell you. All right, so this is Hank asking for their records. So, Unsolved Productions is the name of the company that they're asking for. So now comes the Commonwealth and respectfully requests this honorable court pursuant to Mass R. Crim P. 17 and Commonwealth versus Lampron issue a court order to Unsolved Productions. The woman's name is Terry, who Karen was working with in that documentary, who basically kind of like backstabbed her in the middle of the production and went all anti Karen Reed stuff. All right, so ordering the keepers of the records of Unsolved Productions, Inc. to produce to the Criminal Clerk's Office of Norfolk Superior Court all unedited video and audio recordings in the possession of Unsolved Productions, Inc. and producer Terry Muir from the docuseries A Body in the Snow, a trial of Karen Reed. In support of its motion, the Commonwealth states the following. On June 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree homicide, manslaughter while operating under the influence, and leaving the scene of personal injury and or death. A jury trial on all 3 indictments began on April 16th, 2024. Following a deadlocked jury and finding of manifest necessity, the court declared a mistrial. The defendant's retrial is scheduled to begin on April 1st, 2025. However, the Commonwealth has assented to the defendant's request to temporarily delay the trial due in part to the defendant's appeal to the First Circuit Court of Appeals. On March 17th, 2025, March 18th, and March 19th, Investigation Discovery and HBO Max aired a 5-part docuseries entitled A Body in the Snow: The Trial of Karen Reed. The aired docuseries is approximately 4.5 hours of a behind-the-scenes look at the defense team as it prepares for the April 2024 jury trial and features extensive interviews with the defendant Karen Reed, attorney Alan Jackson, attorney David Yannetti, and attorney Elizabeth Little. Terry Muir, president of Unsolved Productions and the producer of the 5-part docuseries, has described in media interviews that the access to the defendant and her defense team was unprecedented. Uh, Unprecedented, maybe? A part of a part of this docuseries, the defendant and her counsel permitted cameras to record their trial preparation sessions in the war room, the car rides to and from court where the defendant and her counsels discuss upcoming testimonies and trial strategies, often commenting on the evidence, prosecutor, or the court, and one-on-one interviews with the defendant and defense counsels. This is like defense strategy. Why the heck would they think that they should be able to get that? Every statement made by the defendant pertaining to the facts and circumstances surrounding the death of John O'Keefe is relevant and evidentiary, especially given the nature of past statements made by the defendant. In this 5-part docuseries, the defendant again makes inconsistent statements with previous statements she has made to law enforcement, witnesses, and most revealing to other media reporters during other voluntary interviews. I want to address this for a second. She's never made inconsistent statements. Her statements have never been inconsistent with her prior statements. Her statements have always been consistent and congruent with one another. She's not, saying that she didn't delete House Long to Die in Cold in her phone when it's clearly deleted and it was clearly searched at 2:27 a.m. She's not the one lying here. She's not the one making stuff up. But yet, we're going to keep saying that she's making all these inconsistent prior statements. No, she's not. All of her statements have been consistent. All of her statements have been she questioned herself in the beginning because she didn't have the facts. And then later she had more facts. And then it was a pursuit for freedom for herself and justice for John because nothing was done, properly and trying to expose all the corruption. And that's what it's been. And it's always been consistent. And that's always what it's been. Like, I don't understand how they keep saying it's inconsistent. So, sorry, I had to get that out. That just irks me. So, for example, the defendant now claims that she unequivocally saw John O'Keefe enter 34 Fairview Road and admits to consuming large amounts of vodka and being significantly impaired. Her position, even within the five-part docuseries, wavers from the claim that she remembers every detail from January 29th to admissions that maybe her memory wasn't as clear where she had been drinking. I don't know about that, but I think she's always said that her memory's not as clear as if she hadn't been drinking. And I don't think she's ever said, I remember every detail about that. When did she say that? The defendant confirms animosity in her relationship, confirms the altercation with Marietta Sullivan in Aruba, confirms her, which Hank says he's not bringing in, by the way, so why is he even bringing it into a motion? Confirms her flirtatious text with Brian Higgins, confirms that she was angry with John O'Keefe and convinced that John may have been cheating on her with other women who resided in the neighborhood around 34 Fairview Road. The defendant further discusses going to John O'Keefe's residence during the late morning on January 29th and mocks Mrs. O'Keefe's opinion that John looked like he had been hit by a car. How is she mocking it? She's fighting for her life and she's saying what happened to her. That's not mocking Mrs. O'Keefe, but cool. I see where you stand, Hank. Contrary to representations made to the court on March 18th, the defendant admits on March 17th aired episodes that she used an intermediary to share discovery with Aidan Carney, then, with permission of her defense counsels, shared public information, presumably all discovery provided to the defense that would ordinarily not be deemed public due to the investigatory nature of the prosecution with Mr. Carney. What? Mr. Carney wasn't under investigation when she was, and it's public information. So even if he's under investigation, him having public information is not a crime. What is he talking about? Mr. Carney then used this material to advance the defendant's narrative and direct harassment of witnesses. That's never been proven in court, so you can't just call that fact, but okay. She further admitted that she spoke with Mr. Carney regularly about the case. Again, not a crime. Further, contrary to representations made to this court on the March 18th episodes, the defendant expressed reckless indifference that the witnesses, many who came to the defendant's aid, have been intimidated and harassed, and the defendant stated, Jen McCabe, it's me or her. Either I'm going down, Jen, or you are. How's that intimidation? When Jen McCabe is like number one suspect in trying to frame Karen. She's the one that was, the intermediary between law enforcement and the Alberts and, and Karen for that matter at the beginning, trying to lead her astray that morning when they were out trying to find John and lying about all of it. I think Karen has every right to feel that way about Jen, and that's not witness intimidation. This five-part docuseries is also ripe of new information previously unknown to the Commonwealth. For example, the defendant's statement that John O'Keefe exited her vehicle holding her vodka soda drink, that she clearly saw John's body from Carrie Roberts' vehicle, and that she pulled a small piece of glass from John's nose. Newsflash, Hank. She doesn't owe you anything. She doesn't have to tell you any of this stuff. And unless she testifies to it, unless she gets up there and testifies, she doesn't have to answer any of these details, none of it. But yet she's still coming forward and telling her story. What does it tell you? She's not afraid of the truth because the truth is on her side. The defendant further reveals her initial beliefs in the immediate aftermath of John O'Keefe's death, stating to Attorney Yannetti and waiving any associated privileges, "What if I ran over his foot, or what if I clipped him in the knee and he passed out, or he went to care for himself and he threw up or passed out?" Again, these are all just random thoughts going through her mind because she didn't know what happened and she's trying to make sense of it, the situation. Your brain would be looking for a solution too. This is not an admission of guilt. It is her brain trying to figure out what the hell happened, because last she saw him, he was walking into the house. Next time she saw him, he's unconscious, bleeding, not breathing. He's in a different state than when she last saw him, and she's trying to figure it out. The defendant has repeatedly used the media to promote her position. Oh, really, Hank? What is the Commonwealth doing? We know that the Commonwealth speaks to and pays certain content creators, some of them with big reaches, like, Jennifer Coffin Doofus, um, to try to spread their narrative. So why can't the defendant speak? This is an utterly ridiculous argument. The defendant has repeatedly used the media to promote her position, explicitly stating in a Vanity Fair article, "If I can get the entire truth, as articulated by the defendant, of this case out in the public forum, that, to me, is priceless." What's wrong with that statement? If she can get the truth, that's priceless. If she can get people to understand what really happened and to see that the Commonwealth is corrupt as hell, that's priceless, because that is the truth. During this five-part docuseries, the defendant declares that doing the film is my testimony. I want to say what happened exactly as it happened. This, I believe that she didn't think that she was going to be heading into trial number 2 after a mistrial. I do think that she thought she was going to be acquitted and therefore didn't think anything of this particular documentary airing before a second trial. I'm sure, she might have thought about that possibility, but she probably didn't think that it was the most likely scenario. So getting this out there would have been a good thing had she been acquitted. Now it's being used against her by Hank. This trial by media strategy has repeatedly been employed by the defendant and defense counsels for over 3 years. The Commonwealth is entitled to, and justice dictates, production of the defendant's own statements, particularly as proclaimed to be what exactly happened. If we want to go down this road, I think we need to get Michael Morrissey's statements with all of the witnesses, Michael Morrissey's, how that whole hostage video came about, and potentially Julie Albert or somebody named Julie was in communication with Michael Morrissey about it due to a FOIA request. We know that. So it's very possible it was Julie Albert that was asking Michael Morrissey to make the hostage video. I think all of that needs to be given over to the defense and discovery. All the communications from David Traub and anyone else in the Norfolk District Attorney's Office to Jennifer Coffindaffer and other content creators, and possible payments to those people. That needs to be disclosed as well. I think if we're going down that road, let's do it. Let's go for that too. Is Hank communicating with any of the witnesses? Is he communicating with um, potential content creators to talk about the narrative. That would be something. Somebody do a FOIA request. That would be great. All right, so in the defendant's various media interviews, she contradicts her own statements and makes admissions that the victim did not appear mortally wounded, that she thought that she clipped and unknowingly incapacitated the victim. Further statements are likely relevant when compared to past statements. The defendant's statements are not hearsay and are instead substantive evidence admitted for its full force of proof. When a defendant deliberately undertakes a public relations campaign and saturates the public and the potential jury pool with statements likely to reach the potential jury pool, they also run the risk that the statements may not be beneficial and be incriminatory. The helpfulness or unhelpfulness of the statement does not direct legal basis for disclosure. The unaired statements made by the defendant and her counsels would be relevant and material to put the relevant aired statements, many which will be introduced at trial, in context. So they're using aired statements at trial and they want any unaired statements to be given over to them. Further, the absence of details provides in the unaired footage is fertile grounds for examination of witnesses at trial. Discussion. Pursuant to Massachusetts Rule of Evidence 801, the Commonwealth seeks to introduce multiple statements made by the defendant. A defendant's statement is not hearsay and is admissible against the defendant when the statement was made by or adopted by the defendant. A statement includes a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. The hearsay exemption for statements by a party opponent encompasses any extrajudicial statements made by a party opponent, not just statements that are inculpatory or against the party's interest. The defendant and her counsel cannot avail themselves of a media strategy to publicize and promote the defendant's varying claims to the public at large and the potential jury pool while simultaneously exercising statements and admissions that may not be favorable to her cause. Further, under Massachusetts law, it is well settled that news reporters do not have a constitutionally based testimonial privilege that other citizens do not have. And this, my friends, is hopefully going to change. There is a legislator, Turtle Boy said it on his show last night, and I don't know if it was a senator or is or a representative, somebody for the state of Massachusetts is putting forth new legislature to protect the reporters and journalists of the state of Massachusetts. And so stuff like this can't keep happening because this is a total overreach, in my opinion. And the fact that they can just go after reporters' privileged documents, even though they say it's not privileged because they don't have a law. Well, make it law. Like, why are we continually doing this over and over again? It's like banging your head against the wall and expecting a different result. We need to change the law, not continually uh, let our defendants' rights be violated like this. And the journalists' rights also are being violated by having to hand over their stuff. In Massachusetts, there is no qualified journalist privilege that protects against disclosure of confidential and non confidential press materials. Even if such privilege did exist, parties seeking disclosure of non confidential materials are entitled to seek discovery from a media entity if they can show that the materials at issue are of likely relevance to a significant issue in the case and are not reasonably obtainable from other available sources. NBC ordered to provide complete and unedited footage from motor vehicle stop where it would assist the trier of fact in assessing whether in a civil rights claim police had probable cause to stop vehicle and to determine whether police had engaged in pattern or practice of stopping vehicles based on race. The records are not otherwise procurable reasonably in advance of trial as they are not held in the care, custody, or control of the Commonwealth or the defendant, and the entity will not produce the records without a court order. The Commonwealth cannot properly prepare for trial without such production and inspection of in advance in trial. How can You can't go to trial without these documents. You were ready to go to trial, but now you can't go to trial without them. I call false. And the failure to obtain such inspection may tend unreasonably to delay the trial. The Commonwealth expects to introduce the records at trial as evidence of the charges against the defendant. Furthermore, the defendant is entitled to review these records in their entirety prior to trial. A part of the Commonwealth's consideration to assent to the defendant's request for a short delay in the trial is in part due to this plethora of new information revealed to a national audience that is extremely relevant and material to the defendant's criminal intent and conduct. An affidavit in support of this motion is attached. So this is why they assented to the defense's motion for a stay till after April 25th, because they wanted time to get these records. They wanted to put in this request so that they could get Karen's words and use them against her. That's all this was about. So here is Hank's affidavit. He says, I am moving to produce records in the above captioned matter. I am requesting a prompt hearing on this motion. So he wants a hearing on this, and in consideration of this court's scheduling order and upcoming trial date. The Commonwealth will hand serve a copy of this affidavit and accompanying motion to the registered agent of the Commonwealth on March 20th, 2025. Unsolved Productions, Inc. is a registered what? Is registered with the Secretary of State for doing business in Massachusetts, has a registered agent in Boston, and the docuseries was filmed entirely in the Commonwealth of Massachusetts during the defendant's first trial. If you remember, there was like Dateline NBC stuff that they were trying to get, and they couldn't get it because New York has journalistic privileges, whereas Massachusetts doesn't. So they didn't have jurisdiction to even get the to even enforce an order on them to get their documents, their notes. Um, on January 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree homicide, manslaughter while operating under the influence, and leaving the scene of personal injury and/or death. On April 16th, 2024, a 10-week jury trial commenced with with Judge Beverly Cannoni at the helm. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses to manslaughter while operating under the influence. 1, involuntary manslaughter in violation of the statute. 2, motor vehicle homicide, OUI, liquor and negligence. On July 1st, 2024, upon finding that the jury was deadlocked, the court discharged the jury and declared a mistrial. The defendant's second trial is presently scheduled to begin on April 1st. However, the defendant has moved for a continuance with the Commonwealth's assent to April 28th. So they didn't know yet what Judge Bev's ruling was going to be when they had prepared these documents. The Commonwealth alleges that on January 29th, 2022, while intoxicated, the defendant struck John O'Keefe with the rear of her Lexus SUV and left him to die in blizzard conditions. At approximately 6:04 a.m., the defendant, accompanied by Jennifer McCabe and Carrie Roberts, discovered the victim, John O'Keefe, alongside the road and outside 34 Fairview Road, Canton, Massachusetts. While on scene, the defendant made statements to first responders that she hit him and that this was all her fault. The defendant has challenged the Commonwealth's evidence in this case to include allegations of police misconduct, claims that the Commonwealth tampered with evidence, and accusations that the Commonwealth has framed the defendant with homicide. These are allegations that the defendant and Attorney Jackson, Attorney Yannetti, and Attorney Little put forth in a 5-part docuseries, A Body in the Snow, the trial of Karen Reed. Oh no. Like, your butt hurt because they're basically saying that the Commonwealth is corrupt, which they are. And you were hired to defend the corrupt Commonwealth. But he's butthurt about that, so he's got to put that in his motion. Importantly, in the aired portions of A Body in the Snow, the trial of Karen Reed features unprecedented access to the defendant and her attorneys during the defendant's first trial. The plethora of information, both from counsels and the defendant, is extremely material and relevant to the charges and the evidence. The defendant's multitude of inconsistent statements and admissions are admissible evidence in both the Commonwealth's case in chief and in rebuttal. What the Commonwealth and nationwide audience has been able to learn and view over the 3 nights of aired footage, I believe it's 5 now, is prolific and newly revealed information. Pursuant to Massachusetts Rule of Evidence 801, the Commonwealth seeks to introduce statements not limited to oral assertions, but also the nonverbal conduct captured on film by the defendant. A defendant's statement is not hearsay and is admissible against the defendant when the statement was made by or adopted by the defendant. A statement includes a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. The hearsay exemption for statements by a party opponent encompasses any extrajudicial statement made by a party opponent, not just statements that are inculpatory or against the party's interest. Commonwealth's motion is not a fishing expedition, sure it isn't, as it is reasonably likely to produce additional statements of the defendant. The limited broadcast is devoid of additional context that will be helpful for the jurors to learn relative to the admission by the defendant. Further, the first trial spanned over 11 weeks, and the production of this documentary followed and recorded the defendant and her counsels leading up to trial and during the entirety of the trial. It is reasonable to believe there is more than the aired approximately 5.5 hours of footage. Thus, the Commonwealth seeks a copy of the evidence in its entirety, signed under the pains and penalties of perjury, Hank Brennan. So, will Judge Bev hand it over like she's handed over everything else? Judge Bev cannot stand, in my opinion, Judge Bev cannot stand that Karen Reed and the attorneys speak out. So I think as like a vindictive measure, she's going to be like, sure, go right ahead and have all the notes that you want. And all of David and Karen's text messages and communications and things. She's she's she clearly has it out for Karen, and she's going to do what she can to help put her away, in my opinion. All right, we have a juror questionnaire, which is 3 pages long. This came out Friday, I want to say. So let's just read through it. So we've got number one. It is alleged that on January 29th, 22, while intoxicated and operating her motor vehicle in Canton, the defendant, Karen Reed, took the life of her boyfriend, John O'Keefe, an off duty police officer. Is there anything about the description of this case, the charges, or the victim that the victim was an off duty police officer that causes you to believe that you cannot be fair and impartial in this case? Yes, no, or not sure are all of their answers. Number two, have you already started to make up your mind about this case? Number three, did you have opinions regarding previous experiences as a juror, the fairness of the jury system or criminal justice system in our country that would impair your ability to be fair and impartial to both the Commonwealth and to the defendant? Number four, do you have any religious or philosophical beliefs that would make it difficult for you to follow the law and come to a verdict in this case? Number five, do you have any religious or philosophical beliefs that would make it difficult for you to be impartial? Number six, this case is expected to garner a significant amount of media attention. Is there anything about the high-profile nature of this case that would prevent you from serving as a fair and impartial juror? Ugh, I can't talk. Do you, any family members, or close friends reside in or conduct regular business in Canton? Would you automatically believe or disbelieve law enforcement officers, firefighters, or first responders simply because of their occupation? It's a good question. Do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about law enforcement officers, prosecutors, or the government? Have you ever been involved in a group community, or individual activity showing support for law enforcement in or outside your own community. Number 11, have you ever been involved in a group, community, or individual activity that was critical to the of the police of law enforcement in or outside of your own community? Ugh, I can't talk. Let me try that one again. Number 11, have you been involved in a group, community, or individual activity that was critical of the police of law, police or law? Maybe that's being critical, like a group against law enforcement, is what that means. Number 12, have you or someone close to you ever had education, training, or work experience in any of the following fields: law enforcement, military, alcohol, drug abuse, domestic violence? Number 13, do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about operating a motor vehicle under the influence of alcohol? 14, have you ever been involved in a group, organization, participated in a march, demonstration, campaign, or donated money on behalf of an organization or cause that was against driving under the influence of alcohol, such as SAD, Students Against Drunk Driving, or MAD, Mothers Against Drunk Driving? Number 15, has anyone close to you ever been involved in an accident involving drinking and driving? If so, would that experience prevent you from being a fair and impartial juror in this case? 16, have you or has anyone close to you been involved in a witness let me start that one over. Have you or has anyone close to you been involved in or witnessed a motor vehicle crash? Number 17, is there anything about crash reconstruction testimony that would make it difficult for you to be fair or impartial in this case? Number 18, have you or any family members or close friends been involved in domestic violence relationship that featured physical, mental, and or verbal abuse? There is no testimony whatsoever that that actually took place in their relationship. So why that's on here, I'm not exactly sure, but it is kind of the theme because they are trying to say that, she just rage motivated her and she just like got angry. So it was a domestic violence case, even though there was no evidence whatsoever of any kind of abuse whatsoever in the relationship. Number 19, have you ever been a victim of a violent crime? Number 20, during trial, you will hear testimony about medical treatment, death, and review graphic autopsy photographs. Will that affect your ability to participate in a fair and impartial as a fair and impartial juror? Number 21, you may find a defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise, which is exactly what the jury in trial 1 did. It is difficult is it difficult for you to understand the differences between circumstantial evidence, speculation, guesswork, and surmise? We'll see. If the defendant does not testify, do you think she is probably guilty or hiding something? Do you know or recognize anyone you have seen today in the courthouse or in the jury pool? Would your answers to any of the above questions be embarrassing or damaging if disclosed publicly, or would disclosure infringe on your privacy? Do you have any concerns about your personal privacy due to the presence of video cameras in the courtroom and or the highly publicized nature of the case? Is there any reason why you do or do not want to serve on this jury? And then here is I believe this was what Liza Little was talking about. She said she wanted to add a third page. So this is more so about, I think media coverage and whatnot. So it asks, do you have any knowledge of this case gained from any source? So have you heard about this case? Yes. Okay, what is your source of knowledge? Television, radio, newspapers, magazine, internet, Twitter, social media, and which one? Podcasts, family, friends, observations in the community, overheard discussions, or other. Let us know. What are the details of the case that you were able to recall? So if you have some details, what were they? Are you aware of any specific impact this criminal allegation has had on your community? Have you heard about the protests, the way that people have been reacting? What is your primary source of news and information? Are you getting it from YouTube creators? Are you getting it from court TV? How often do you read print or online newspapers, magazines, blogs, and what sources? How often are you exposed to news from radio, television, podcasts, and social media, and what sources specifically? What is your familiarity with the case prior to today? Have you had discussions about this case prior to today? Is there any reason you would be unable to follow an instruction that during your jury service you may not read any news or media accounts about this case, watch or listen to any media or news broadcasts or commentary about this case, discuss this case with anyone, research or look this case up on the internet, or perform independent research? So all the admonitions that you get from the judge every time you come in and out of the courtroom, basically all those things are, would you be able to follow that or not? Is there any reason that you would be unable to follow an instruction that during your jury service you may not read or view any social media articles, posts, videos, podcasts, or other non traditional media platforms that may discuss this case? And finally, is there any reason that if you are inadvertently exposed to extrajudicial influence or media about this case, you would be unable to follow an instruction that you must report an exposure to the court? So if you do hear anything about it, would you come to us right away and tell us? Basically, is what they're asking there. So I think a lot of that's pretty standard stuff, especially for this type of, um, for these charges. Like a lot of the questions are good for these charges, pretty typical stuff. All right, finally, the last thing I wanted to bring to your attention was that the defense filed an updated defense witness list, and Kevin Albert has been added to the list. Kevin Albert is the brother of Brian and Chris Albert, uncle of Colin, also a Canton police officer. The reason why the case was recused from Canton PD, even though they still used Canton PD for a lot of the investigation, but they recused themselves somehow. And her car was brought to the Canton PD Sallyport. Where was he that day? What were his actions? Who did he contact? Because if you recall, Kevin Albert was setting up interviews with Katie McLaughlin, the firefighter who said, she said, I hit him, I hit him, I hit him. And oh, yeah, I don't know a Caitlin Albert. I went to school with a Caitlin Albert. Whatever. Even though there's like photos of her and Caitlin Albert growing up together over the years, so they obviously know one another. But if you remember, Kevin Albert, this came out in trial, Kevin Albert was communicating with, I want to say he was communicating with Proctor or Buchanan, one of them, and setting up the interview with Katie McLaughlin and other EMTs to come in to the. So remember, they were recused because of Kevin Albert, but Kevin Albert's setting up interviews with the EMTs and firefighters to come in to meet with Proctor and Yuri Buchanan. So hopefully they question him on that. And maybe there's more about Kevin Albert that we don't know, and that would be excellent to see him being examined by the defense. I think that's going to bring out some more clarity as to what really happened that night and the hours following, which are important because that's where the cover up lies. So those are the details that we need to know. So, what do you guys think? Let me know in the comments below. Please don't forget to like this video and make sure you are subscribed as I go through all of the documents as they drop. And also, by the way, in the description below, I think I forgot to say this earlier, there is a link to all of these documents that I went through. So if you want to go through them on your own, especially the federal appeals ones, the opinion from Judge Saylor, and the motion to stay that got denied immediately. If you guys want to go read those on your own, because I did not read those. But for the most part, I read through everything. A lot of the federal stuff is repetitive because they keep going over the same details over and over again. So I haven't been reading those. But everything else we go over. So thank you guys so much again. Thank you for being here and have a good one. Bye.